Security Disability Benefits hearings. My name is Sylvia Soltis, and I'm a senior staff attorney at Legal Aid in the Pro Bono program. We're grateful to have you with us today. I'm joined by my colleagues, Andrew Patterson, senior staff attorney in our Public Benefits unit, and Sacha Robinson, staff attorney with our Reentry Justice Project and Public Benefits unit. I'd like to flag a few quick items for our attendees. First, we are recording this training. So after the presentation, we'll share the link to this recording along with the training materials so that you have it accessible to you in the future. Second, if you have questions throughout the presentation, please type them in the Q&A box at any time. We'll be monitoring that throughout the training and have reserved some time at the end of our training to address your questions. Third, we'll be taking a 5-minute break in the middle of the training with the hope that we can all avoid Zoom fatigue. With all those pointers out of the way, I want to share just a little bit about Legal Aid, especially for those of you who are new to our organization. Legal Aid is DC's oldest and largest civil legal services organization. We were founded in 1932. And we like to say that for almost 90 years, we have been making justice real in individual and systemic ways for persons living in poverty in the district. Now, Legal Aid is primarily Legal Aid is primarily an in-house organization with roughly 90 individuals on staff. And I'm proud to share that this past year, we helped roughly 10,000 people living in poverty on a variety of areas, including housing law, public benefits, domestic violence, family law, and consumer law, just to name a few. Yet, Legal Aid receives thousands of requests for help each year. And frankly, even with almost 90 individuals on staff, we do not have capacity to help everyone who contacts us. And we're unable to provide a lawyer in all cases in which we might be able to make a difference. That's why I'm so grateful that you're here, and hopeful that you'll consider taking a pro bono case from Legal Aid. Our pro bono program allows us to expand our impact by providing legal assistance and representation to hundreds of additional individuals and families in the district. It is through our partnerships with attorneys just like you that we can help more people in DC. So again, thank you for coming. And if you have questions about Legal Aid's pro bono program, please feel free to reach out. Now, with that, I'm going to turn it over to my colleague, Andrew Patterson. Andrew represents clients in a variety of legal matters, including Medicaid and Medicare, Social Security disability benefits, food stamps, temporary assistance for needy families, unemployment insurance, and several other district health programs. Andrew also serves as an expert mentor on public benefits cases to our pro bono attorneys. So if you accept a public benefits pro bono case from Legal Aid, there is a good chance you might just have him as your mentor.
Thank you, Sylvia. So my name, as Sylvia said, is Andrew Patterson. I'm a senior staff attorney with the Public Benefits Unit. And I just wanted to start by reiterating a couple of things. First is that we want to thank you all for being here, for participating in this training. We're excited that you're here, and we hope that a lot of you will take cases in this area. There is a great need for it in the district. With regards to questions, please do type them into the Q&A function if you have them. We will try to maybe answer sort of very easy questions like, what does this acronym stand for, or something, as we're going through, but we're going to try to answer the more substantive questions at the end, because we do have a lot of material to cover. By sort of just the nature of this training as well, a lot of people may have questions that will be a little more specific to a client situation. And so I just want to remind people that if they take a pro bono case, you will be assigned a mentor from Legal Aid, and that mentor will be available to you to talk to you about the individual circumstances of your client, and also be able to answer a whole lot of questions that you will inevitably have, especially if it's one of your first Social Security cases that you're taking on a pro bono basis. And that said, I'm going to try to not talk too quickly, but I do have a lot of material to cover. So I'm going to try to make sure that I cover it in the allotted time so that we have time for our break. Sasha has time for her presentation and that we can get you out of here in a reasonable amount of time. So today, what are we going to be talking about? We're going to be talking about working with clients who have SSI and SSDI legal matters. We'll be talking about key concepts with these programs. How do SSI and SSDI cases work? What are the issues that you're addressing? We'll have a lot of case handling tips and procedural tips for how to prepare and how to conduct a hearing on one of these types of matters, and then also go through some resources and support at the very end. And before we get into the substance, I just want to sort of talk about the kinds of people who can be affected by these cases. This is a really critical program for people who are disabled and unable to work. One example of that is a former client of ours, Mr. Columbus Keemer. Mr. Keemer had a variety of medical conditions that severely limited his ability to do work activity, yet he applied for disability benefits. He was denied. He was denied after his first stage appeal. And it was only after a legal aid attorney took his case and worked with him, presenting the evidence, in a really compelling way, that the administrative law judge at the hearing approved Mr. Keemer's benefits. And the judge approved them not only prospectively, but retroactively to his date of application, which, netted him more than $13,000 in back benefits. So as you can imagine, especially for people who have little or no income in the District of Columbia, that is a very substantial benefit and a very significant amount of income and back benefits that he should have been getting the whole time and may not have gotten but for the assistance he received from an attorney. First, I just want to talk a little bit about the client population that you'll be working with and some of the unique challenges that you should be prepared to address. You just want to consider your client's background and daily challenges. A lot of our clients, by the nature of the case that they have, they're going to have significant physical or mental health conditions. They may be caring for someone, in many cases a child, who has significant physical and or mental health conditions. The inability of work itself is challenging for a lot of people to accept. They will have very little or no income, which of course, as we know, presents a whole slew of challenges. And they may have little to no experience with lawyers, or the experience that they have with lawyers may not be good experiences. So, I think those are things to really sort of keep in mind as you're meeting your client. I mean, these are a lot of the situations that will be informing how they sort of interact and how they approach their own legal matter. You'll want to create a plan for staying in contact with your client. I mean, that's always, of course, important. I think that's even more important now during COVID times when in-person meetings are happening a lot less. But for example, it's hard for clients sometimes to maintain consistent phone service. So you may want to have a plan, like an alternate number to reach out to them on through a friend, through a relative, if you find that they're having trouble maintaining consistent phone service. They may not be available for scheduled meetings, because something comes up. Pre-COVID, people may have had issues with transportation. And I know, knock wood, hopefully we'll be going back to a version of normal relatively soon. And that will come up again in the future. Or, people may just not be available at the agreed upon time because they're dealing with some kind of emergency that comes up in their life. In terms of client counseling, again, some things to keep in mind. Many times these kinds of cases involve very, difficult or sort of intimate conversations with your client about very sensitive issues, things like intimate personal details, substance abuse, traumatic experiences that people have had. Unreported income. People may not want to report certain income that they have, or may not understand that they have an obligation to report it. In many cases, it may make sense to wait to have some of those more difficult conversations beyond the first meeting. It may be a good idea to sort of build a little bit of trust with your client before you talk about some of those more challenging situations. There are going to be certain clients who have mental illness that may be a part of their, disability argument. How is that going to affect meetings and other interactions? One thing that we have found, one resource that can be really helpful for people, especially with very severe mental illness, is if they have someone in their life who they already have a trusting relationship with. That can be a relative, it can be a parent. It can be someone like a social worker or a caseworker or a case manager. Those can be really valuable contacts for you to make if someone is facing some of those mental health issues. And also, we're going to talk a little bit about children's disability cases, child's SSI cases. The client is the parent in that situation on behalf of the child. And at that point, you're not able to keep secrets from the parent, from things you may learn from the child. That's an important thing to keep in mind. And some of the same challenges that apply when our clients, are facing these mental or physical health issues, living in poverty, are also going to apply to parents of children who are in those situations. So, maintaining good communication, transportation, trying to address barriers to the representation ahead of time so that the parent and the child can fully participate are going to be very important. For folks who want to, we have another pro bono story. I'm not going to talk about this one as much because I want to make sure we get to the substantive training. The key concepts we're going to talk about today, we're going to talk about the two different disability programs that we work with, SSI and SSDI. How are they similar? How are they different? We're going to talk about the eligibility requirements. How do people qualify for these programs? We're going to talk about how Social Security decides that someone is disabled, both for adults and for children. How do people meet that requirement of establishing that they are in fact disabled and entitled to benefits? We're going to talk about the award of benefits. What does that mean? What do people get when they're approved? And we'll talk about the appeal process, the sort of application and appeal process. How does it typically go from application to hearing and even beyond when people are trying to get approved for benefits? So I'm going to start by talking about SSDI and SSI. What are they? So SSI stands for Supplemental Security Income. SSDI stands for Social Security Disability Insurance. These are the two principal disability programs that Social Security administers. They are similar in some ways to each other, and they are very different in some ways to each other. They are similar in that both programs require claimants to be medically disabled. We're going to talk more about what medically disabled in the Social Security context means, but and that is going to be most of what you are addressing as a representative for clients in these matters. Most of the work that we do in these cases is helping people prove to Social Security that they are in fact disabled and they should qualify for benefits. And both are administered by Social Security, but SSI is a means-tested, need-based program for people who have low income and low resources, while SSDI is not means-tested. It doesn't care about other income, but people do have to have a substantial work history to apply for and be approved for SSDI. So SSDI is based on how much someone has worked in the past. Sometimes people can get approved for SSDI, but they may have a very low benefit payment amount. In that case, sometimes people can receive both. They can get SSDI plus some SSI to get them up to the maximum SSI payment amount, which I will talk about. And the note on this slide is important. People who apply for SSI are automatically considered for SSDI as well, because Social Security has a preference to pay people out of the revenue stream that funds SSDI. However, the reverse is not true. So if someone applies for SSDI and they do not have a substantial work history, they will need to make sure that they have applied separately or asked to be considered separately for SSI, because they want to make sure that even if they don't have enough work history for SSDI, but they are disabled, they can at least get some payment amount. So this is just a brief summary of eligibility for SSI and SSDI. Like I said, for both programs, people have to establish that they are disabled, and the first step in that is not performing substantial gainful activity. So, and we're going to talk more about this disability sequence in a few minutes. Both have to show that they are medically disabled. But as I was saying, SSDI is means tested. So first, people have to meet the income test, which means that they have less than $794 for 2021 in countable income. $794 is the maximum SSI payment amount. So if someone is approved for SSI and they have no other income that would count against it, $794 is what they will get for their monthly payment amount. They also have to show that they have low resources, which means that they have less than $2,000 in countable assets. Some kinds of assets will be excluded. If you have questions about that, that is an excellent question that you could talk about with your mentor. But they have to show that they have less than $2,000 in countable assets. And finally, SSI has a pretty restrictive immigrant eligibility requirement. People have to be either a US citizen or they have to be a qualified alien, which is actually a very narrow category of legal presence in the United States. So there are many, many people who have some kind of legal immigrant status, but are not going to qualify for SSI. SSDI, on the other hand, does not care about income or resources. It's not means tested. It does care about someone's work history. So people have to show that they have what is called insured status, which means that Social Security, from the time someone says they became disabled, their onset date, will look 10 years back into their work history. And that person will have to show that they worked and paid into Social Security for 5 of those previous 10 years. The actual requirement is a 20 and 40 work quarter requirement. So 10 years is equivalent to 40 work quarters. And for 20 of those work quarters, someone has to have worked and paid Social Security taxes on their income. It doesn't matter how much they paid in any particular quarter, but they have to show they paid something in at least 20 of those previous 40 work quarters. And there is a more permissive immigrant eligibility standard for SSDI. Someone has to be a US citizen or simply show that they are lawfully present. This is Social Security's definition of disability. This is sort of a term of art. I'm not going to spend a lot of time talking about it because we are going to talk more detail how Social Security decides that someone is disabled on the next slide. But this is just what Social Security means when they say disabled. So what does disabled actually mean in Social Security? It means that people are not able to perform work activity at the substantial gainful activity level. I'll tell you what SGA means in a minute, because they have a medically determinable impairment that is essentially a permanent disability. There's a 6-step evaluation process for determining whether someone is disabled within Social Security's meaning. So the first is to examine whether that person is working, and if they are they performing substantial gainful activity? Substantial gainful activity is a dollar figure that changes every year. It goes up a little bit whenever there's a cost of living adjustment to the Social Security benefit. For 2021, it is $1,310 per month. So the first thing Social Security will look at before they look at medical records, before they look at medical conditions or any of that, is this person working and making $1,310 per month? If the answer is yes, then that ends the analysis and the application will be denied. Social Security assumes that no matter what someone's medical condition is, if they're able to work and earn this amount or more, that they are not disabled. Assuming someone is not earning SGA, we move on to step 2, which is another sort of threshold eligibility criteria, which is, does the claimant have a disabling condition that significantly limits his or her ability to work? And there's a couple of terms of art that I want to talk about. So disabling condition, another term is medically determinable impairment. And that is the idea that every symptom that someone has, whether it's a physical symptom or a mental health symptom, has to be tied to an actual diagnosed medical condition that could reasonably be expected to produce those symptoms. So if someone has some kind of severe back pain or something, but despite being evaluated by doctors, they're not diagnosed with any sort of back condition, then that pain will not be taken into account unless it can be tied to a medically determinable impairment. It also has to significantly limit someone's ability to work, which is Social Security's definition of severe. So it's not how most of us would define the term severe in our own mind necessarily, but that's actually under Social Security's rules a relatively low threshold to meet. It is not impossible, but it is usually uncommon that people will lose a case because their condition is not considered to be severe. And also wrapped up in step number 2 is this issue of what's called a durational requirement. The durational requirement, and there's a citation that I'll give you in a minute for this, But the durational requirement means that someone's medical determinable impairment, their disabling conditions, have to either, number one, be expected to result in death, which thankfully we are not in the position of having to argue that very frequently, or number two, have to have lasted for a continuous 12-month period or be expected to last for a continuous 12-month period, which is typically what we argue in these cases. And the idea behind the durational requirement is, again, these are not disability programs for people who, for example, break their leg and may not be able to work and they're a construction job, but their leg is expected to heal relatively, soon, and they will be able to go back to work, hopefully. These are programs for people that have long-term medical conditions that render them unable to work. So steps 1 and 2 are essentially threshold requirements. If a claimant does not meet the requirements of step 1 or step 2, then they lose their case, and that's the end of the analysis. Assuming someone wins at step 1, assuming they win at step 2, step 3 is kind of the first real sort of detailed analysis of their medical condition. Step 3 asks, does the claimant's medical condition meet or medically equal the requirements of a listed impairment? And I'm going to show you an example of a listing on the next slide, but the listings are pretty self-explanatory. It is a list of various medical conditions, all of which have their own sort of individual criteria. And someone has to meet those criteria of that medical condition in order to prove that they are disabled. And if they do, if someone wins at step 3, if they show that their congestive heart failure meets the requirements of the congestive heart failure listing, they will win. Social Security then determines they are in fact disabled. And unless there's a step 6 analysis, which I'll talk about, that's the end of the analysis and the person wins their case. If they lose at step 3, if they do not show that their medical condition meets a listing requirement, then at steps 4 and 5, they sort of get this second bite at the apple. They get another opportunity to show that they are still disabled. And at steps 4 and 5, and we're going to talk about this in more detail as well, but key to steps 4 and 5 is this concept of residual functional capacity. And what that is someone's leftover ability to do work once all of their limitations are taken into account. And Social Security at step 4 will ask, is the person able, with their current residual functional capacity, to return to work they did in the past? If they are still able to do their past relevant work, then the person loses and the case is over. They lose at step 4. If the person shows that they are not able, physically or mentally, or physically and mentally, to go back to their past work, then we move to step 5, which is they have to show that they are not able to adjust to any other work in the national economy. Technically, this is Social Security's burden to show that the claimant can adjust to other work. In reality, it's sort of still the claimant's burden because at the end of the day, they have to show there is no other work at all in the national economy that they are able to do on a full-time basis. If they are able to adjust to other work, no matter how limited that other work, other full-time work, then they will win. They will lose their case. But if they show they are not able to do any work at all, then they will win. Step 6 only is addressed if there is a history or diagnosed problem with alcoholism or drug abuse. But if there is, and if someone has won at either step 3 or steps 4 and 5, then there is this added step of showing that the drug or alcohol addiction is not the proximate cause of their disability. And we're going to talk about that more in a minute as well. This is just an example of and I'm sorry, I wanted to give everyone the citation for the durational requirement. That is 20 CFR section 404.1509. And that talks, it's like 2 sentences long, but it talks about what the durational requirement is. At step 3, so we're talking about the listings again. This is just an example of a listing. And the listings, people can either show that they meet the exact criteria of a listing or that their condition is medically equivalent to the criteria in a listing. So this is just one listing for systemic lupus erythematosus. I, years ago, had a case involving SLE, where I made a medical equivalence argument. You'll see at subpart A, number 2, that there are several signs or symptoms that must be documented to win out an argument based on this listing. Medical equivalence is this idea that even if you don't meet, or the claimant doesn't meet the specific criteria in this listing, if they have other medical conditions that are of equal medical significance as determined by a doctor, then they can still win their case. So in my case, my client did have well-documented severe fatigue, but fever, malaise, or involuntary weight loss were not a part of her lupus, but headaches were, and they were directly tied to her lupus. So we were able to make a medical equivalence argument in that case, arguing that although she had severe fatigue and nothing else, she had headaches, which were of medical, the same medical severity as the other criteria. And so we were able to win on that basis. In your binders, if you reference tab number 24, there is some additional information on this concept of medical equivalence and how you can incorporate it, if necessary or if appropriate, into your disability analysis, into your claimant's disability argument. At step 4, so assuming, if someone wins at step 3, obviously that's great. And, if there's no step 6 analysis, that should be the end and that person should win their case. I think the reality is that more often than not, we generally lose cases at step 3, even cases that we ultimately end up winning, unless it's a physical health condition where the criteria are very objective and it's clear that someone meets those criteria. It can be harder to win, for example, mental illness cases or cases that involve a little bit more of a subjective analysis at step 3. So typically, if we lose at step 3, the analysis moves on to step 4 and step 5, which, as I was saying, involves this concept of residual functional capacity, which I'm going to talk a little bit about because it's relevant at step 4 and at step 5. So as I said earlier, residual functional capacity is this concept of once you assess someone's medical condition, and once you assess their symptoms, and once you assess all of the limitations that result from those medical conditions, what is that person's remaining ability to do work activity? So this is a sort of very simple example, but for example, someone with a very severe back injury or leg injury may have the residual functional capacity to only stand for 30 minutes or an hour in an 8-hour day. Most of us, hopefully, who are healthy would be able to stand for, 5, 6, 7 hours in an 8-hour day. It would depend. But a residual functional capacity, that's what it will look like. Someone might have, someone with a very severe mental illness or traumatic brain injury, may have the residual functional capacity to only listen to and follow very simple instructions, or they may not even have that residual functional capacity. They may not have the ability to follow simple instructions if they have very severe mental or, certain types of cognitive limitations. So once someone's residual functional capacity is assessed, and that is the responsibility of Social Security, at step 4, Social Security will perform a vocational assessment of that person's past work. What were the demands associated with the past work that this person did? At step 4, the concept of past relevant work is usually work that is done within 15 years. So if someone was a construction worker, but that was 30 years ago, then that's not relevant. You don't have to prove that they cannot go back to that job. It's only 15 years back from the date of onset of disability that's considered past relevant work. It also has to be work that was done at that SGA level. So if someone was doing, really heavy work, but they did it once or twice a month for a friend, and they earn $500 a month doing it, that is not considered to be. Where I was that I was explaining that past relevant work is work that's done in the past 15 years, and it is work that is done at the substantial gainful activity level. So once someone's residual functional capacity has been assessed, that is compared to that past relevant work, to the demands that are involved in the person's past relevant work. And if it is decided that they are able to return to that past relevant work, then they will lose at step 4, and that will be the end of their case. One key note is that even non-severe impairments, so impairments that people have that are still tied to a medically determinable impairment, but that do not meet that severity definition of step 2, those need to be taken into account when assessing someone's residual functional capacity. So that's an important thing to remember at step 4 and 5 when arguing that someone is disabled. You really want to throw in or include every limitation that is supported by the medical evidence, regardless of whether, Social Security decides or whether even you would think that it meets that severity criteria. So if someone wins at step 4, if they show that based on their residual functional capacity, they are not able to return to their past work, the analysis moves on to step 5. Uh-oh. There we go. The analysis moves on to step 5. Uh-oh, I keep messing that up. So at step 5, Social Security will then assess, can a person with this claimant's residual functional capacity, now the residual functional capacity does not change or anything between steps 4 and steps 5. Residual functional capacity is just this ability, what is this claimant's ability to do work activity? So it's the same analysis that applies, but the question changes. The question at step 5 becomes, can they do other, less demanding work in the national economy on a full-time basis? The first step in determining whether someone can adjust to other work is to take their residual functional capacity along with their age, their education, and their work experience, and to compare those criteria on this thing called the grids, which are the Social Security Medical Vocational Guidelines. I can't remember if, I don't think the grids are actually in the training binder, but they're very, very easy to Google. We don't have them on this slideshow, but when you Google them, you will see that they literally direct a finding of either disabled or not disabled for a whole bunch of different situations based on these criteria. So for people with a light exertional capacity who are a certain age with this certain education experience, who have a work experience and skill level of XYZ, based on all of those criteria in a bunch of different situations, the grids will compel a finding of either disabled or not disabled. If the grids compel a finding of disabled, if the grids say, based on this person's residual functional capacity and taking into account their age, their education, and the type of work they've done in the past, they are disabled, then they win at step 5 and they will have proven that they are disabled. If the grids determine that someone is not disabled, then in many cases, that is the end of the analysis and they lose. However, there is a very, very important exception to a grids determination that someone is not disabled, which is if the disability that someone is arguing includes non-exertional impairments. Now, exertional versus non-exertional impairments are, pretty self-explanatory. Exertions are things like sitting, standing, walking, lifting, pushing, how much weight can someone carry? How long can someone physically exert themselves while doing work? Non-exertional impairments tend to be a little bit more, in some cases they're objective, in some cases they're a little more subjective. But the most frequent non-exertional impairment that will come up in our clients' situations are mental health limitations. Things like difficulty remembering instructions, difficulty understanding instructions, difficulty carrying out instructions, difficulty getting along with other people, getting along with coworkers, with supervisors, with case managers, not case managers, with like the general public. How able is someone to adjust to change in their work setting? These limitations, when they are very severe, can greatly limit someone's ability to work, even if physically, they can lift 100 pounds with no problem. The rules say that when someone is suffering from both exertional and non-exertional impairments, the grids do not, whatever the grids determine for that person are not binding, but they serve merely as a guide. And those non-exertional impairments have to also be considered before a final decision on disability can be made. So that is a very important thing to remember. And it's a very important thing in many cases to incorporate into the arguments that one is making for their claimant. If you go in your training binders to tabs 25, 26, and 27, you will find several Social Security rulings. These are sort of, opinion statements issued by the Social Security Administration that talk about how are non-exertional impairments assessed in the disability analysis. And they can be very, very helpful to cite to when you are arguing that someone, even if the grids say that someone is not disabled, they can be very excellent sources of citations for arguing that someone's non-exertional impairments really do in fact mean that they are disabled, that they cannot do full-time work on a long-term basis. These are the medical vocational guidelines. I'm not going to spend a lot of time on this, but these are the different categories that are taken into account in that grids analysis. So again, you'll see exertional level. Remember, this is just exertional level that goes into the grids. Those non-exertional impairments are not considered at this point. They come if the grids say someone is not disabled. But the grids will consider the person's exertional level, their age, their education, and the skill level of their past relevant work. The grids can be found, if you just Google Social Security grids, they will come up. They'll be the first or second thing that you see. But if you're looking for a citation, they're at 2, and this is at the bottom, it's 20 CFR Part 404, Subpart P, Appendix 2. So let's say that you are, arguing a case and you have made the arguments at step 3. You've made all of the arguments regarding listings, regarding residual functional capacity at steps 4 and 5. If there is a history of drug or alcohol addiction, then you may have to consider incorporating a step 6 argument. And that is because, as I said earlier, if Social Security finds that someone is disabled, whether it's at step 3 or at step 4 and 5, they have to then determine in these cases if the past or current drug or alcohol addiction is what's called a contributing factor material to the disability. Another way of thinking about this is the question that Social Security is posing at step 6 is, is someone disabled notwithstanding any drug or alcohol abuse? It cannot be the proximate cause of that disability. This step does not come up, anytime there is any reference at all to drug or alcohol use. The sort of threshold criteria for does Social Security even engage in this analysis, and it's usually called the DAA analysis, which stands for drug abuse or alcoholism. That's how you'll see it in regulations and policy guidance and all that. But the DAA analysis only applies if a person has a diagnosis of a substance use disorder. So, in some cases you may see, especially in a mental health case, where if someone has coexisting mental health and substance use disorders, or not disorders, but substance use. But if someone has occasionally used alcohol or has used illegal drugs, but if they have not been diagnosed as having a substance abuse disorder, then this analysis doesn't even come into play. It's only when someone has that diagnosed substance abuse disorder that step 6 has to be engaged. And as I was saying, what Social Security wants is evidence that they would still be disabled even if they were to stop using alcohol or whatever drugs are at issue. This is not usually an issue with a physical health limitation, or for, an example that sometimes I have had asked of me is for example, if someone is, has a long-term problem with alcohol and they've been diagnosed with cirrhosis of the liver, and that cirrhosis has progressed to the point that it is disabling. That is not what this is getting after, because someone with cirrhosis could stop drinking, but the damage may be done. So that person would still qualify for benefits if they're disabled. This is more, if the drug or alcohol abuse stop, does the person improve to the point that they are no longer disabled? The way that we try to do that, or the sort of gold standard of evidence that Social Security wants, is to show that during periods of abstinence, if people have documented periods of abstinence in their records, did all of their symptoms essentially remain at the same level of severity? Because if so, in particular in mental health cases, that is very, very strong evidence that the drug abuse or substance abuse is not the cause of their symptoms. Because if those symptoms stay during periods of abstinence, then it must be linked to the mental illness. Very frequently clients will be able to demonstrate through periods of abstinence that their medical condition essentially stays the same. If so, that's the evidence that you really want to highlight in a step 6 argument. It is not always the case, though, that people will be able to document that. The law is a little bit less clear in those circumstances. We argue, for example, that, and this is very frequently backed up by people's treating psychiatrists, their treating counselors, and all of that. But if someone is using drugs or alcohol in order to essentially self-medicate their symptoms, we have argued, and there is some support for this, but it is not necessarily ironclad, and depending on the federal circuit, I think there may be some bad case law. I don't think there's any controlling bad case law in the DC circuit, but we will argue that, look, the treating physician is willing to say that even though there is some ongoing substance abuse, it is not the cause of their disability. It is a symptom of their disability. And so, depending on how supportive the treating physician is, depending on the circumstances of your individual client, depending, unfortunately, on the judge who is hearing the case, that can sometimes be a successful argument, but it is a little bit more difficult to make this argument if there is no, really well-documented period of sobriety. And I'll also reference you to tab 28 in your training binder, which is Social Security ruling 13-2P. And that offers some pretty robust and additional guidance on when the DAA analysis needs to be done and how that analysis is conducted. If this comes up in a case that you were handling, I would also definitely recommend that you talk to your mentor about it, your legal aid mentor. You'll have a lot of probably questions that are sort of related to your client's individual circumstances, and the mentor will be more than happy to talk through you on that. I mean, obviously we can't anticipate sort of every situation that will arise in a kind of higher level training. So that is essentially going through the disability analysis for adults. Now, the disability analysis for kids is different because Social Security does not have an expectation that children are doing full-time work. So the question that Social Security is asking is not, is the person able to do full-time work? The question is the child meeting certain developmental milestones for their age? So if a child has a medical condition that means that they are not meeting those developmental milestones, that is when Social Security will approve benefits for a child. As opposed to the 5-step analysis previously, this is a 3-step analysis, and it is similar in some ways, but it is also different in some ways to the adult analysis. The first analysis, again, is the child performing substantial gainful activity? Obviously, that's not going to be an issue for very young children, but for older children, in their teens or whatever, who may be working, in some occasions, that issue has come up. It's step number 2. There is the same sort of medically determinable impairment / severity requirement that has to be met. So again, steps 1 and steps 2 are very similar to the analysis in adults. And these are essentially the same threshold questions that have to be met before one moves to step 3, which is the more substantive analysis. At step 3, Social Security will assess whether the child's medically determinable impairment meets or medically equals a child listing. So in addition to adult listings, there is a whole list of medical conditions that are child appropriate. And so the first is, does the person meet or medically equal a listed impairment. Meet or medically equal in this context is, again, very similar to meeting or medically equaling a listing for an adult. I think actually in the case that I referenced earlier involving lupus, where I made a medical equivalence argument, that was actually a child's case involving the child listing for lupus. If they do not meet or medically equal a listing, which is the step 3 of adults, again, there is sort of this catch-all that is also built into the child's step 3 analysis, which is, do they functionally equal a listed impairment? And functional equivalence is sort of, I mean, it's similar in idea, I think, to this idea of residual functional capacity. I mean, it is different. It's not the exact same thing because, again, residual functional capacity is about ability to work, and children are not expected to work. But it is similar in the sense that it's this, somewhat broader category of disability that lets children in this case show that they are disabled, even if they do not meet or medically equal a child's listed impairment. So the idea behind functional equivalence is that Social Security will assess children in 6 different domains, and those domains are listed below: acquiring and using information, attending and completing tasks, interacting and relating with others, moving and manipulating objects, caring for yourself. I mean, you can see that some of these are sort of more child appropriate than they are for adults. And the idea of functional equivalence means that a child has either 2 marked impairments in any 6, they have marked impairments in any 2 of the 6 categories, or they have an extreme limitation in 1 of these 6 categories. I think the training materials may talk a little bit more about marked and extreme. Basically there's this sort of subjective level of severity. Social Security has 4 different levels of severity. They have mild, moderate, marked, and extreme. So someone can have moderate limitations in all 6 of these areas. That's not enough to establish disability under this functional equivalence standard. They have to show marked, which Social Security sort of helpfully defines as more than moderate, but less than extreme. But they have to show marked impairments in 2 of these areas, or they have to show an extreme limitation in 1 of these functional areas. Again, if I have handled many child's cases, many other attorneys who are mentors at Legal Aid have handled a lot of child's cases. We will talk to you in more detail about how to approach these. You'll have individual questions about them, and we'll be happy to sort of, talk you through how do you think about children's cases in a lot more detail, should you take one of them for representation. And finally, before we take our break, I'm just going to talk a little bit about COVID-19, some of the developments that have happened in terms of Social Security as a result of the COVID-19 pandemic. Consultative examinations are being done remotely, and they are being done in some cases in person right now. Consultative examinations are exams by a doctor that Social Security will pay for. Clients can ask for a consultative examination. It is usually scheduled at the request of Social Security. The administrative law judge may want, a second opinion, so they may want the claimant to go see and have a consultative examination conducted. Maybe the administrative law judge feels that there is a lack of medical evidence or development of medical evidence around, a certain impairment that is at issue. So consultative examinations will be scheduled by Social Security. It is very important, if this comes up in your case, the client attend the consultative examination. If they don't, that can result in a loss in their case. Social Security field offices are still closed for most purposes. They are now doing express interviews for people who need to have original documents reviewed, who don't want to, mail those original documents in, which is never a good idea. If you have to mail something into Social Security, the client should always do it via certified mail or something where it can be tracked to show that they have actually submitted what they said they submitted, or, sending a fax so that you have a record of that fax going through. But to the extent that people need to submit original documentation, this comes up sometimes in immigrant eligibility issues. These express interviews are happening in those situations, but by and large, the Social Security field offices are still closed for walk-ins. And finally, Social Security has issued some guidance on evaluating disability cases that involve COVID-19. At this point, there is no listing for COVID-19. So there is not, I know that a lot of us have heard of this sort of long haul COVID, where people can have very, severe COVID. Right now, COVID-19 by itself, there is no listing for arguing that because of long haul COVID, someone is disabled. There is, however, some guidance that Social Security has issued, which is in this link, to how someone's COVID-19 symptoms, limitations, and all of that can be factored in to the disability argument. So to the extent that any of you represent someone who may have long haul COVID as part of their medical disability, I would highly encourage you to click on this link and to read over this guidance, because it will probably be very helpful in your case. So I think
Okay, that's been about 5 minutes, so let's get started again, everyone. Again, my name is Sacha Robinson. I'm a staff attorney at Legal Aid in the Public Benefits Unit. So Andrew this morning has discussed the substance of how Social Security makes decisions about who is disabled and who is eligible for Social Security benefits. But now I want to talk a little bit about what happens if you are indeed found eligible and found disabled. What type of benefits do you actually receive? So for supplemental security income, SSI, like Andrew mentioned, you receive a maximum amount of $794 per month. For this type of benefit, there are no derivative benefits. So only the individual who is found disabled can receive benefits. Their children or spouse don't receive benefits just because the individual is receiving SSI. In addition, the payments that you receive start from the date of your application. There is no waiting period before you can receive those payments, and you qualify for Medicaid if you receive SSI. For SSDI, again, which is based on work history, your payment amount is based on your work earnings. So how much you've paid into the system over the past 10 years determines how much you will receive in payments. The average benefit level right now is $11.97 a month, but that can vary greatly. And if someone was working at lower wages, then it's possible that their monthly payment will be much lower than that. There are derivative benefits allowed for SSDI recipients. So it is possible that that person's children, spouse, or even former spouse might be eligible to also receive benefits on the basis of one person receiving SSDI. The benefits can start from the date of onset of disability. So it's not necessarily when you file your application, it's when you are found to have are found to have become disabled, and you can get paid for up to 1 year prior to your date of application. However, with SSDI, there is a 5-month waiting period before you receive benefits, and you will receive Medicare, but only after 29 months from the date of onset. So Social Security has an extensive appellate process, and most of the cases that legal aid refers out to pro bono attorneys are at the hearing level. So that means that when you, the pro bono attorney, enters the case, the individual most likely has already been denied twice. So they've submitted an initial application that was denied, and they've also requested reconsideration, a second level appeal that was denied. Because most cases that we refer out are at the hearing stage, that's what we will be focusing on today. But I do want to note that in the event that someone loses at the hearing stage, there are still levels of appellate review available, and that's at the Appeals Council and Federal District Court. We do have some materials in the written manual that addresses things to consider if someone loses at the ALJ hearing stage. And we generally advise people to talk with their mentors to consider whether or not they want to represent that person in further appeals. Okay, so Andrew's half of the presentation focused a lot on the substance and the law. The second half of the presentation, the goal is to focus on what do you as the attorney need to do to handle these cases, to prepare your client for a hearing, to prepare yourself for a hearing, and strengthen your case. So things that we'll be talking about include the primary tasks for you to help prepare for the hearing, how to build your case and how to develop crucial medical evidence, writing a brief, preparing for the hearing, the logistics of how to file before Social Security, and some additional resources and supports available to you in addition to this PowerPoint and the written materials that we distributed. Okay, so the primary tasks in these cases are interviewing and counseling clients. That's a crucial element. Submitting forms and communicating with the appropriate administrative agencies, mostly Social Security, collecting, reviewing, submitting, and strengthening medical evidence, and preparing a brief to supplement that evidence. We'll be discussing most of these in coming slides, but I do want to take a moment to talk about that first meeting that you have with your client. Like Andrew mentioned at the beginning of this presentation, oftentimes our clients have not worked with attorneys before, or have not had good experiences with attorneys. So at that first meeting, it's really important to explain the process, explain what's going to happen, what's already happened, and kind of provide that framework, what your role is as the attorney, and what your client's responsibilities and role is in this case. At that initial meeting, when it's happening in person, then you would go through all of the paperwork with the individual, but you can have them sign a retainer, sign different HIPAA release forms so that you have permission to gather their medical records, and also have them sign a form 1696, this is the appointment of representative to Social Security and notifies them that you will be the attorney on file, and that they have permission to release records and disclose information about the claimant to you. When you're meeting in person, you want to copy any correspondence, letters, notices that they have from Social Security. Sometimes clients might have some copies of their medical record or discharge reports from the hospital. Any written documentation that they have related to Social Security or their health condition are things that you want to copy at that initial meeting. This is also a good time to go talk about their medical information, to start gathering information about their different conditions, what providers they see, how frequently they see them, what symptoms they experience. This is really a good time to start building that relationship so that in future conversations, you can have those discussions about sensitive information. Like I said, these appeals can last a while. Sometimes from the date of application to the hearing, it can take up to 24 months for the individual. And these are people who are alleging that they are disabled and unable to work. And so what that often means is that they have very little or no income at all. And that's a long time to go without any income at all. So I encourage all attorneys to discuss with their clients at the initial meeting the availability of other DC cash assistance programs. Two main ones that might apply to your client are interim disability assistance, or IDA. Another potential program is temporary assistance for needy families, or TANF, and that's available to claimants who have minor age children or school age children. Also, I want to reiterate that it can often be hard to stay in touch with your client. These cases last a long time. It can be difficult for people to, keep their phone number in service, have the same phone number. So really, this is a good time to establish a contact plan, alternative methods of contact if you're having a hard time reaching them at the phone number that they use primarily, and just to make sure that you're planning out how frequently you're going to touch base to stay in touch with your client. If there's one thing that you take away from the second half of the presentation, I hope it's that medical records are so very crucial in these types of cases. And so you will want to do your best to develop the medical evidence that Social Security has on files. And so some types of medical evidence that might come into play in your case are medical records, of course, residual functional capacity assessments. So like Andrew was talking about, the RFC is crucial to steps 4 and 5 of the sequential evaluation. And so you can have doctors, caseworkers, psychiatrists fill out a RFC form that details what someone struggles with, what their limitations are. And there is a sample in the table of contents in the manual that we provided. And the RFC is on, it's tab 36, 35 and 36. It's possible that Social Security will find that they want to schedule a consultative examination for your client. In rare instances, you can request a consultative examination as well, but that helps develop the medical record. You can get affidavits or letters of support from the claimant themselves, from third parties like family members, social workers, case managers who interact with the individual on a regular basis and might be able to provide helpful description and information about the individual's limitations. And from medical providers themselves. Medical providers can provide opinions about the limitations that an individual experiences. And depending on when the SSI or SSDI application was filed, those opinions can might be required to be given serious deference by Social Security. In all of these different pieces of medical evidence, the more detail that's in the records, the better. The more helpful it is when you are writing your brief and trying to state your case before an administrative law judge. For children's cases, in addition to medical records, you should also be requesting the child's school records. So relevant records include report cards, IEPs, 504 plans, any records related to special education or disciplinary reports, and really any activities or records that document the child's performance or their behavior. You might also want to consider asking a teacher to complete a teacher questionnaire. This is a form that Social Security has, and again, it's provided in the written training materials, but it allows the teacher to provide insight into the child's development as compared to other students and provide detail about what the child's limitations are. So a successful Social Security case often involves the client and the attorney working together to create the strongest case possible. So I encourage you to encourage your clients to play an active role. They should be taking notes on their conditions. You should encourage them to discuss all their symptoms with their doctors. Oftentimes, they'll tell you about certain limitations they experience, and when you review the medical records, those same symptoms don't appear. And so that's a part where you can step in and counsel your client about the importance of them telling their doctor about all of their symptoms and all of their impairments and limitations so that that is reflected in the medical evidence. It might be helpful to be involved with a social worker or a caseworker or a community support worker. Oftentimes they have different names. To communicate with the doctor about the disability standards and the need for medical evidence that would support a disability claim. Often social workers and caseworkers can play a very important role in communication with your client, but also communication with the different medical providers. You should encourage your clients to the extent that they feel able to follow up on treatments and to keep appointments with medical providers. It might be necessary or imperative for you, the attorney, to help in certain cases. So for example, if they need help completing medical forms or a disability appeal report, this might be the chance to really put in those details that help these cases, helping them document functional limitations, preparing them for a consultative examination, which again is with a Social Security doctor paid for by Social Security, or if they're having barriers in connecting with medical providers or staying in touch, staying in treatment. Sorry. Okay, so I now want to kind of walk you through medical records, how to use them, how to gather them, what you're doing with them, because again, medical records are crucial to these types of cases. So the first step is just the logistics of getting these medical records. So again, you need to get HIPAA releases signed by your client that will allow you to collect those medical records from their providers. To actually go about making the request, you need to create a cover sheet for each set of medical records with the claimant's name, social security number, name of the provider, and treatment dates. You need to disclose all treatment sources to Social Security, and you submit those records that you receive to the hearings office, and you can do that through fax or through an electronic system that is called ERE. There are instructions in the written material about how to sign up for ERE, and I encourage you to start that process fairly on in the referral process when you start working with a client. Please don't wait to finish your brief before you submit all of the medical records to the hearings office. You can do that well in advance of writing and submitting your brief. Okay, so the second step is reviewing and analyzing the medical records now that you have them. So you want to review the medical records, focusing on the discharge statements, the doctor's notes, progress notes, sometimes they're called. It might be required that you look up medical abbreviations and terminology. You do not need to be a medical expert to take these types of cases. I would argue that most Social Security attorneys are not medical experts. So just, the internet is your friend here. If you're reviewing the medical records and see abbreviations or terms that you're not familiar with, stop, take a minute, look it up, and that will really help your analysis. As you're reviewing the medical records, it's helpful to create a chart that lists all the symptoms that they're experiencing, the medical conditions that they have, things that you think will be helpful as you argue through the 5-step sequential evaluation that Andrew went through. This will help you when you go to write the brief. Also, something else you should keep in mind is whether any symptoms or diagnoses are missing from the medical records. Again, if your client told you about a problem that they're experiencing and you don't see that reflected in the medical records, you should have a conversation with your client and see if perhaps they need help facilitating a referral, for example, to a specialist, or if they need reminder to discuss that particular issue with their current provider. Okay, so the third step about using medical records is to actually use them. So you've gathered them, you've analyzed them. Now it's time to put those to use. So when you are writing your brief, which you will submit to the judge in advance of your hearing, you want to cite to helpful medical evidence in your brief. So I have a citation format recommended here, but it's really just critical to be citing to those helpful medical records that you have gathered and analyzed. Claimants and representatives have an obligation and responsibility to inform Social Security about all evidence that relates to the disability claim. So that includes both favorable and unfavorable evidence. So not only do you have an obligation to inform Social Security about those medical records, but you also have to submit all medical records that you request and receive in its entirety. There's some limited exceptions about, work product or duplicative records, but for the most part, you need to be submitting the entire medical records that you receive. I just want to make one last point. When you are developing the medical record, it might be helpful to get a statement from a doctor or some other medical provider. You have an obligation to disclose to Social Security if you assisted with drafting or preparing that medical opinion. So that's just something to keep in mind as you are strengthening and building the medical record. So in terms of actual work products that you need to complete before the hearing, the main one is the representative brief. So this written document provides a vivid picture of the individual to the administrative law judge. The goal should be to provide a clear link to the functional impairments. And so you want to discuss all of the important medical evidence and really focus on the facts as they exist within the 6-step sequential framework that Andrew went through. So you don't need to restate the statute and regulations and rulings. This really is your chance to pull the helpful information from the medical evidence and put that within the framework, the 6-step framework. So once you've submitted all of the medical records, you've submitted your brief, now you're ready for the hearing. The next step's the hearing. So these hearings occur at the Office of Hearings Operations, also called OHO. They are informal, so there's no opposing counsel. These generally happen in 2 main parts. So the first part of the hearing will often be the claimant gets to testify, and if there are any other witnesses, then they can testify. And each judge has a different style, but there will be some combination of attorney asking the claimant questions and the judge also asking questions. And you shouldn't be surprised if the judge will interrupt the questioning to ask for more information or to clarify a response or question for the claimant. The second half of the hearing is focused on vocational expert testimony. And the vocational expert is who Social Security brings in to help them with the steps 4 and 5 analysis. So this is Social Security trying to determine, can this individual return to their past relevant work? What are the requirements of that past relevant work? And whether or not the individual can adjust to any other work in the national economy. So again, that's steps 4 and 5. The way the vocational expert testimony works is that the judge will ask a series of hypothetical questions describing a claimant's limitations to this vocational expert or VE. And that person, the VE, will testify about whether someone with those limitations can work. You will have the opportunity to cross-examine this vocational expert. In a few slides, I'm going to provide some more guidance on vocational expert cross-examination. So hearings are going on during COVID. They are continuing. However, they are currently being conducted by phone or video. The video platform that Social Security uses is Microsoft Teams. At this point in time, it is not mandatory to have a phone or video hearing. The claimant can opt out of either of those remote methods of having a hearing. The only downside is that we do not know at all yet when Social Security will resume in-person hearings. They have not indicated when those hearings will resume, and so it's possibly many months out still. We have here some tips for phone or video hearings that you might not think about with in-person hearings. So one is just make sure the client has a quiet place where they can be alone with a good phone or internet connection to participate in the hearing. You really want to make sure that the judge will be able to hear the client, that the client will be able to hear you, and that there are no distractions or no other people around who could be impacting what your client says. Social Security does not have a call-in option for the hearings. They call the claimant and the attorney for the hearings. And so it's important to make sure that they have your correct phone information and your client's correct phone information. So they will include that on the hearing notice, but it also, you can just call the hearing office shortly before the hearing to confirm that they have the correct contact information. Similarly, with Teams video hearings, they will email you and the client the information. So it's important to make sure that they have an accurate email address for all parties. The last point, the last tip that I want to provide about video and remote hearings is you might want to consider an alternate method of communicating with the client during the hearing. And so usually if you're in person, you could be writing notes or having you could have a quiet conversation off the record with the claimant, which you cannot do in a phone or video hearing. And so you might want to consider whether there's another phone or another method of being able to communicate with your client if they have questions or if you need to have a brief conversation off the record. Okay, so moving back to what happens in that hearing. After you've had your client's testimony, again, we will have vocational expert testimony. The judge will ask this vocational expert about the claimant's ability to do their past work and their ability to adjust to other work. Again, steps 4 and 5 of the sequential evaluation. The judge will pose questions to the vocational expert, and they will describe a hypothetical person whose age, education, work history, and limitations are equivalent to the claimant's. We as the attorneys have the right to cross-examine the VE, and if we think if we think that the ALJ's description leaves out key limitations, then we should include that information in cross-examination. So for example, if the judge describes a hypothetical person who can stand for 6 hours in an 8-hour day, but you feel that the medical evidence shows your client can only stand for 1 or 2 hours in an 8-hour day, then you should include that limitation in your cross-examination of the VE to determine what type of jobs are available to someone who can only stand for 1 or 2 hours in an 8-hour day. So when you cross-examine the VE about mental health limitations, I want to provide some guidance. So the judge will usually require the questions to be about a reduction in performance capacity. So rather than saying, the individual has a marked ability to interact with others, Social Security, the judge will usually require you to talk about someone's reduced ability to interact with others rather than using moderate, marked, or extreme. One of the general rules of cross-examination is that you don't ask a question that you don't know the answer to, and that can present some challenges when you think about preparing for vocational expert testimony. So I want to provide some touch points upon which it's commonly expected a vocational expert will provide answers in a certain way. So VEs will commonly testify that if an individual misses 2 to 3 days per month of work on a regular basis, that would render someone unemployable, and thus someone would not be able to perform any work. Similarly, vocational experts will usually testify that someone being off task from assigned duties for 15 to 20% of the workday would render them unemployable. So for example, if someone experiences mental health symptoms, such as difficulty concentrating, difficulty following instructions or working with someone, if they're experiencing pain and that pain distracts them or causes them to take breaks, those are things that would require them to be off task. And so if they would be off task up to 15 to 20% of the day, usually the vocational expert will say that person would be unable to work. There's additional guidance on non-exertional and mental impairments, and that can be found in Social Security ruling 8515 and 96-9P. One of the written material tabs, tab 23, discusses the various sources of law in Social Security cases and where to find them. So that can help you find these SSRs for your cases. Okay, so you need to submit all of the medical evidence and brief in advance before the hearing. But when you first start the case and you have that initial meeting, you got your client to sign a 1696, which again is just the appointment of representative, essentially notifying Social Security of your appearance in this case. So you want to fax that to the hearing office, and I have the fax number provided on the screen. Once you fax that to the hearing office, then you can start the process of becoming registered for Electronic Records Express, ERE. And ERE allows you to file electronically, which is the recommended method of filing. So you have to submit all of your medical records and brief to the hearings office at least 5 business days before the hearing. And you can do that by ERE or by fax. If you don't have ERE, you can request that the hearings office send you a barcode. And so you'll get a sheet of paper with a barcode and some information about your claimant, and you are supposed to put that as the cover sheet in your fax. And that will help Social Security associate those records with your claimant's with your claimant's profile or record. So I don't want to spend too much time on this piece, but if you receive an unfavorable decision at the hearing stage, again, there are further avenues of appeal. The next stage would be the appeals council. The appeals council only reviews for legal error, conclusions not supported by substantial evidence, new and material evidence, or abuse of discretion. You have to file a request for review within 60 days of the date of the unfavorable hearing decision, but then you can request additional time to submit a legal brief. If you get a positive outcome at the appeals council stage, most likely it will result in remanding for a new hearing. Likewise, if you're denied at the appeals council, which frequently happens, the appeals council has about a 14% positive outcome rate. So if you appeal to the federal district court, you have to file within 60 days. The rules of civil procedure apply in these appeals. And again, a positive outcome usually results in remand for a new hearing. The upshot of all of this is that if you receive an unfavorable hearing decision, you should talk to your mentor and consider whether you can represent the claimant in an appeal to the appeals council. So there are resources and supports available to attorneys who take these cases. We have our written materials, this PowerPoint, and we also provide all of that information to our pro bono attorneys. There are training materials available on probono.net/DC. There's a whole public benefits section. You should also look to your own firm to see if there's anyone who has developed subject matter expertise, if there are colleagues who have represented clients in SSI and SSDI cases at the hearing stage. Last but not least, if you are assigned a case, you will be assigned a legal aid mentor who is available to answer your questions and support you in your very crucial and important representation of clients in disability hearings before Social Security. So with that being said, that's the end of our formal presentation today. If you have, we can now accept questions in the Q&A, but I also want to put up here that if you have substantive questions about this presentation and you have not been assigned a case, so you do not have an expert mentor from legal aid yet, then you can reach Andrew and I at these email addresses listed here. And if you have questions about taking a pro bono case or getting that process started, you can reach out to Sylvia, and her contact information is also provided here. But with that, we can conclude our formal presentation and open the floor for questions.
So I see a question here. When submitting medical records to Social Security, can we exclude medical records on unrelated and highly sensitive conditions, or must they be shared as well? Out of an abundance of caution, the general rule is that you are supposed to submit all of the medical records that you receive to the Social Security Administration. I mean, I think it would have to be a unique circumstance to exclude records. The rule is essentially one of transparency. I mean, I think Social Security's reasoning is that there were some attorneys over, time or whatever who would sort of cherry pick medical records. They would show the supportive records, but not show the records that may not be of supportive. So the design behind the rule is that you're supposed to submit everything that you get from a medical provider to Social Security. If this sort of comes up in an individual matter, I would definitely consider talking to your legal aid mentor. I guess it's possible there may be some situation that I'm not thinking of right now where maybe it might be appropriate to withhold. But that's kind of my reaction. I don't know, Satya, if you have any additional thoughts.
No, I agree with that. And I think most likely Social Security would want to be making the decision about whether the medical records are relevant in the case. And because all conditions, even if they're not severe, go into the analysis of what someone's residual functional capacity is, it seems like it would be a rare and unique situation that medical records would not need to be shared with Social Security. So there was a question in the chat that says, is it possible for pro bono attorneys to get an ERE account to avoid fax? The answer is yes, yes, yes. We absolutely recommend that you get an ERE account. There are instructions on tab 15 of the written materials that you are provided. It can be a lengthy process, so I encourage you to start it as soon as you have a signed 1696. There are workarounds, again, if you can't get access before the time of your hearing, but we absolutely encourage everyone to sign up for ERE. It's much easier than fax. And it also gives you access to all of the exhibits, all of the records that Social Security has, and those will continue to be updated. So although you can request a static copy of the evidence as it exists at a moment in time, that's continuing to change and be updated. And so ERE access really is the most fulsome and best access to have.
So I see another question in the Q&A. Is there currently a backlog for ALJ hearings? So there is typically a backlog. This is true pre-COVID as well. You know, when someone requests a hearing in pre-COVID times, we would usually tell that claimant and the pro bono attorney that it would be, you know, around 1.5 to 2 years before the hearing is going to be scheduled. Interestingly, we have seen actually hearings being scheduled more quickly than that for claimants who are okay with a phone hearing. So I think it's actually become a little bit more difficult to predict exactly when a hearing will be scheduled. In the time of COVID, I think, you know, the phone hearings has allowed more hearings to happen. You know, they can sort of bring in judges from other jurisdictions a lot more easily to hear those cases. The rule is that when someone's hearing is ready to be scheduled, or when it is scheduled, they are supposed to get 75 days notice from the notification of the hearing until that hearing date. And so that is longer than it used to be. It used to be, I think, I can't remember what it used to be, but it used to be substantially shorter, something like 20 days or something like that. And so there should be a pretty substantial amount of time from the time you're notified about the hearing until the time the hearing happens. But we have seen kind of a wider variety of timeframes. We've seen 6 months from a hearing request to a hearing being scheduled. You know, we've still seen them take longer than a year. I think it just really depends at this point. And I have not really been able to sort of discern any kind of rhyme or reason to when hearings are being scheduled right now.
On that note, I also want to highlight that, you know, when a pro bono attorney takes on a case, you know, when that hearing is going to likely take place is really dependent on when the client is coming to us. So once we've screened the case, it's possible that you might have somebody who just was denied at the reconsideration level, in which case you'd be looking at the timeline that Andrew has pointed out. But if somebody is coming later on, it's very possible that either they've already had their hearing, and in which case it might be that the ALJ has suggested that they will, continue the hearing until that person gets legal counsel. Then you're looking at a shorter time frame. And Andrew, you can correct me if I'm wrong, but at that point you're looking more at like a 3-month window. So while I think that the information applies generally to when hearings are scheduled, I want to sort of highlight from the pro bono perspective, when these hearings take place will really depend on when the client is coming to legal aid.
I think those are all great points. Thanks, Sylvia.
I'm thinking maybe we can wrap up on Q&A if you all agree, unless others have a lingering question.
I think that's right. If anyone has questions that they think of later, feel free to reach out to Sacha or I. We'll be happy to chat. But yeah, that makes sense to me.
All right. Well, I hope you all found today's webinar informative and also inspiring in terms of what you can do to help those who cannot work due to their mental and or physical disabilities. Navigating Social Security's appeal process is difficult enough for unrepresented claimants under normal circumstances. And now that so much more is being handled remotely, it really can become daunting for our clients. So as I mentioned earlier, I'm grateful for you attending today. I'm hopeful that you'll take a case. Pro bono attorneys like you can make a critical difference in claimants' lives in obtaining the benefits that they need to make ends meet and to which they are legally entitled. Please reach out if you have any questions about our referral process or just substantive questions. As I mentioned, as I think it's been mentioned before, our pro bono cases provide training resources, expert mentors assigned to the case. We try to have you as prepared as we can be to handle the matters. All right. Well,
I see actually one more question that came in through the Q&A. There's a question about any advice on economical ways to obtain client medical records. We are encountering less cooperation from medical record companies on waiving fees for pro bono clients. So yeah, I mean, I think back in the day, we would have encouraged you to emphasize that this is a pro bono case and that you're not charging a fee to the client. Just a couple of things off the top of my head. I mean, I have heard from pro bono clients that that is less effective. So the asker of this question is not the only one who's encountered that. A couple of things that just come to mind right now are number one, especially if you have the Electronic Records Express, the ERE access, you can look and see what is already on the record. Oftentimes clients have already submitted records as part of their initial application or their reconsideration appeal. Those records should still be in the electronic file. Social Security is supposed to request records as well. One of the things they ask initial applicants is, where do you get your medical treatment? Who are your doctors? What hospitals have you been to? And they will request and very frequently do get medical records from those places. They don't do a lot of follow-up. They don't try particularly hard to get records, but see what's already on the file. Another idea is to especially if the client has, a sort of long medical history, but the disability is a more recent development, you can try to limit the scope of the request that you're making. You can limit it to, for example, a certain time period. If the disability issue arose in 2018, but this is, the person's been going to like a doctor for a long time, but the previous records aren't as relevant to the disability, you can request records back to a certain date. And that should at least hopefully shrink the overall size of the records that you will be getting. But yeah, I don't have a great answer. It's definitely a bit of a conundrum. That's definitely something I think a pro bono mentor would be willing to help you sort of think through in terms of, how can you be strategic with the request? How can you see if this is something that Social Security already has, or, something along those lines.